Jurists and academics have called for the abolition of the penal courts of peace due to their controversial and arbitrary detainments, arrests and judgments. The Justice and Development Party, AK Party, has been criticized by jurists and legal experts for empowering the penal judges of peace who serve in these courts. An appeal made to a decision of a penal judge of peace is sent to another penal judge of peace, whereas normally the appeals process should move vertically, meaning a higher court should have jurisdiction. Head of Law and Life, Penal Courts of Peace used for witch hunt. Mehmet Kasap, the chairman of the Law and Life Foundation, spoke to today's Zaman and underlined that President Recep Tayyip Erdoğan had made his intentions clear when the penal courts of peace were first being formed by calling them project courts. Kasap explained that the penal courts of peace violate the principle of natural judge, about which is written in the Constitution: no one may be tried by any judicial authority other than the legally designated court. These courts, penal courts of peace, were, and still are, being used to carry out a witch hunt. All that is happening shows that Turkey will be held to account at the European Court of Human Rights. Recalling that the worst form of torture is that done by the hand of the law, Kasap said, all in all, the ruling elite found 15 to 20 judges with whom they took the law hostage. CHP deputy, penal courts of peace used to intimidate dissenters. Mehmet Kasap, Istanbul deputy for the Republican People's Party, CHP, said the penal courts of peace are clear proof that the law is being used to intimidate dissenters. Underlining that today the law has become politicized via the penal courts of peace, Kasap, who is also a lawyer, stated, in the last year there have been alignments in the legal system. There are groups in the legal system such as the supporters of the ruling party and its dissenters. Supporters of the ruling party were hyped up by the government due to the decisions they gave, whereas those who rendered decisions according to the law were penalized for not being on a par with the ruling party, explained Kasap, continuing, we the CHP are working on a bill that will allow individuals to appeal decisions of the penal courts of peace to a higher court to abolish its extraordinary powers. Former head of Turkish Bar Association, law has become tool to protect certain individuals. Vedat Kosar, the former president of the Turkish Bar Association, TBB, said in reference to the penal courts of peace that the law had become a tool to protect certain individuals, according to a report in the Bugün Daily on Thursday. These courts are project courts. They serve those in power. The decisions they have given proves this to be true. The rule of law has been pushed aside and the law has become a tool to protect certain individuals, he said. Penal courts of peace answer only to themselves. The penal courts of peace have also been heavily criticized due to their closed-circuit system of appeal. For instance, when an appeal is made to a verdict of a criminal court of first instance, the appeal comes before judges of a high criminal court. In contrast, an appeal to a decision by a penal court of peace can only be made to a different penal court of peace, the same level of court, and often to the same judge who issued the original ruling. The penal courts of peace were designed by the government to target critics and opponents by orchestrating what appear to be mock trials in politically motivated cases. Criticizing the closed-circuit system of the penal courts of peace, Kosar explained, the appeal to a lower court decision must be made to a higher court. This principle has been abolished. Also, you appeal decisions made by the penal courts of peace to the judges of peace. The system is broken in that way. Law professor, penal courts of peace need to be abolished. Metin Gunday, a professor of administrative law at Atılım University, expressed the need to abolish the penal courts of peace. The appeals against the detainment periods practiced by the penal courts of peace are not to a higher court. The appeal needs to be to a higher court. If you appeal a decision given by, for example, a penal court of peace judge named Ahmet to another penal court of peace judge named Mehmet. Ahmet inspects Mehmet and Mehmet inspects Ahmet. Could there be such a thing? This is where the biggest mistake is made. Gunday, if the arrest of judges was translated into German, I'd be sent to psych ward. In April, Judge Metin Özçelik, the former head of the Istanbul 29th Court of First Instance, accepted an appeal regarding the recusal of a penal court of peace judge due to a violation of impartiality regarding the case of a jailed journalist and several police officers. Ojslik forwarded the case to the Istanbul 32nd Court of First Instance headed by Mustafa Basir, who ruled for the release of Hidayet Karaka, detained in December 2014 on suspicion of being a leader of an armed terrorist network because of a script for a TV series aired on Samanyolu TV in 2009, in addition to over 60 police officers. The Supreme Board of Judges and Prosecutors, HSYK, decided to suspend Basir and Ojslik on April 27, 2015 over their ruling. Subsequently, the two judges were arrested on April 30 and May 1, respectively. Gundai said that if he had translated these series of events into German, presumably for colleagues to understand, he would be locked up in a psych ward. Lawyer: Their cases will show how unlawful these judgments are. According to lawyer Serkan Sakal, the penal courts of peace have no corresponding concept in law. These penal courts of peace render template decisions. When the decisions these courts pass are taken to the we will see how unlawful they are.